The latest filing in the ongoing Ripple lawsuit has sparked confusion and speculation within the XRP community, with many assuming it signaled an issue with the U.S. Securities and Exchange Commission (SEC). However, Marc Fagel, a former SEC lawyer, has stepped in to clarify that the filing has no connection to the SEC's actions. Instead, the notice targets Ripple's co-founder Chris Larsen, highlighting a procedural matter that may impact the case. On October 18th, the United States Court of Appeals for the Second Circuit issued an acknowledgment and notice of appearance default notice in the SEC versus Ripple case. This notice was quickly picked up and shared by prominent figures within the XRP community, such as Sherry on X. The notice prompted speculation that it was directed at the SEC, with some XRP supporters theorizing that if the regulator failed to comply, it could risk having its appeal dismissed by the court. The filing states that the appellee's counsel missed a critical deadline to submit its notice of appearance by October 18th, as required by court rules. Furthermore, the court warned that failure to submit the acknowledgment within 14 days of the notice could prevent the legal team from presenting oral arguments unless special permission is granted. As rumors swirled that the SEC was the target of this filing, Marc Fagel stepped in to provide much-needed clarity. Fagel explained that the filing does not involve the SEC, but rather concerns Chris Larsen, Ripple's co-founder and chairman, who is one of the appellees in the case. According to Fagel, Larsen's legal team failed to submit their notice of appearance on time, which led to the court issuing the default notice. The legal team now has until November 5th to comply with the court's directive, or they may be barred from presenting oral arguments in the future. Meanwhile, the focus shifts back to Ripple as the company prepares to file its own Form C this week. Ripple had previously filed a cross-appeal notice on October 10th, aiming to challenge the district court's ruling that deemed its institutional sales of XRP as investment contracts. Ripple's chief legal officer, CLO, Stuart Alderety, confirmed that the company's pre-argument filing is expected by Friday, October 25, 2024. The Form C filing will present Ripple's arguments for why it believes Judge Annalisa Torres erred in her ruling on institutional sales. Once Ripple submits its brief, both parties will begin coordinating the schedule for submitting their full appeal briefs. Alderety has suggested that the SEC may have up to 90 days to file its opening brief, with the final briefing process likely extending into July 2025. While the latest filing stirred speculation about SEC noncompliance, it turns out the notice is directed at Ripple's co-founder Chris Larsen, marking a minor procedural issue in the broader legal battle. As Ripple gears up for its next move with the Form C filing, the legal complexities of this case continue to unfold, keeping the XRP community on edge as they await the final outcome. So, that's the update for now. Thank you for watching, and see you in the next video.